the recommendations made to the Ministry of Information Technology. In an era where data has emerged as a strategic asset, India has risen to become the third largest digitalized economy globally, supported by a foundation of 1.39 billion biometric identities and over 1.14 billion mobile subscriptions. This is quoted by the Observer Research Foundation report. Likely, India's regulatory landscape has undergone a transformative shift with the enactment of Digital Personal Data Protection Act 2023 and the subsequent notification of the DPDP rules on 14th November 2025. Together, they establish a clear roadmap where substantive compliance obligations for organizations will commence shortly, and as our learned panelist will guide us through. As per the above mentioned, what I just mentioned, the Observer Research Foundation report, the urgency for this transition is underscored by escalating risks in our digital ecosystem. The recent data indicates that the average cost of a data breach in India has already risen by 28% between 2020 and 2023, reaching an average loss of US $2.18 million. As per a report of why 2025 is a make or break year for cyber resilience and why most firms are not ready yet, by Accenture India, shows a significant readiness gap. The numbers are whopping, as surprising they are. 90% of organizations currently lack the maturity to counter modern AI-enabled threats, and 77% have yet to implement foundational data and AI security practices. High-performing, reinvention-ready organizations are 69% less likely to suffer advanced AI-powered attacks and 1.5 times more successful at blocking threats when they do occur. This resilience cannot be built overnight. This can be built when the governance systems, the governance mechanisms are robust, they are kept in check and functioning. As per another report, in India, cyber attacks have surged by over 100% between last 4 years. So with rapid expansion of digital services, the increasing sophistication of cyber threats, data leaks, and heightened awareness of individual privacy rights, data protection has evolved from a compliance obligation into a strategic business priority. The DPDP Act is India's first comprehensive statutory framework for digital personal data protection, and the recently released rules provide the much needed operational guidance on consent notices, security safeguards, breach reporting, data retention, erasure, and enhanced protection for vulnerable groups such as children and persons with disabilities. Unlike sector-specific frameworks, the Act creates a unified, horizontal governance structure that applies across industries while maintaining proportionate compliance obligations. The DPDP rules 2025 implement an 18-month phased deployment roadmap with foundational provisions taking effect immediately and substantive compliance obligations commencing in a phased manner. This webinar is designed to equip business leaders, compliance professionals, legal counsels, and IT and/or security executives with a deep understanding of how the Act and rules align with global privacy standards, such as the European Union's General Data Protection Regulation, GDPR, commonly known, while reflecting India's unique digital ecosystem priorities. Beyond compliance, the webinar will also highlight how incorporating privacy centric frameworks drives competitive advantage by strengthening consumer confidence and mitigating business risk. This webinar is designed to, and with help of our esteemed panelists, will certainly help us in bridging the clarity gap, helping the audience achieve and navigate a digital economy that contributed 11.74% of India's GDP in year 2022-23 and is projected to reach 20% by 2029-30. I'll just briefly summarize the key discussion points that our panelists will take us through in the webinar. Introduction and emergence of data privacy concerns, um, in the plenary phase, the global data privacy principles and practices compared to India's approach, Digital Personal Data Protection Act 2023 and the DPDP Rules 2025, privacy in organizations where most organizations fail, security safeguards and breach management, AI and algorithmic accountability gap, assessing fairness, transparency, and risk of harm in algorithmic decision making. And the journey, the most intricate part, to the compliances and a slew of compliances and governance measures that this new law is proposing. With this, I now extend a very hearty welcome to our learned panelist for today's webinar, Ms. Nikita Kothari. Her accolades will alone take me quite some time to read out. But for starters, she's an accomplished chartered accountant, an IPP certified privacy professional in Europe, DSCI certified privacy professional, and also a partner at Corporate Professionals, Nagpur. She is a chartered accountant with over 8 years of experience in compliance and internal audits across leading financial institutions, including ICICI Bank Limited, Axis Bank Limited. She is also, as I told, a certified professional in field of data protection and privacy with a strong expertise in European and Indian data protection laws. And why only European? Let me say, in the global data protection laws. And her close working with banking and financial sector institutions have given her first-hand experience and deep insights into how actionable and implementable governance infrastructures are built to comply with data protection norms. She has extensive experience in anti-money laundering compliances, data protection regulations, RBI and SEBI guidelines, and has served as compliance officer at ICICI Investment Management Company in her past role. Over to you, Ms. Nikita Kothari.
Thanks, Ravi, for such a warm welcome and introduction, and also for setting up the pace for this webinar. Actually, it is quite fruitful that you've, presented all the statistics before we actually begin with why data protection is actually a game changer and quite important for the organizations today. So, quickly, let me just begin by sharing my presentation. So, basically, in today's digital era, data is one of the most valuable assets for businesses, governments, and individuals. And with the increasing rise in data breaches, cyber threats, and privacy concerns, data protection has actually, become a critical focus for the organizations, not only in India but also globally. So one way to think of privacy is basically a series of choices. So if you'd like a service to offer you turn by turn directions, you choose it to give your location, for example, a Google map. And suppose on Amazon, if you'd like a shopping website to remember what's in your cart, you choose to allow cookies. But companies have gotten so good at exploiting these choices and, in many cases, obscuring the true nature of them. So, simply if you click agree on the app's terms of service, so there is a terms and condition, tab, and simply if you click agree on it, in the eyes of an exploitative company, that the app will not only take the information you are giving up, but it will also sell it to other companies. It will also share it with the other companies. So people cannot learn, enough about the privacy risks to make an informed decision. But that doesn't mean we don't care. Even if we don't place a high value on our personal data privacy, we may have strong concerns about, how an organization is actually surveilling us, monitoring us, and making profit out of our personal data. But why was the need of a personal data protection privacy law in the first place? We'll just go through it. Like, what are the concerns which actually made the government across, the countries? Now we have laws in Europe, then we have it in the US. But why was the need in the first place? Firstly, for the protection of an individual's right and dignity. So, personal data, basically your identity details, your biometrics, your health, location, your financial information, it is closely linked to an individual's dignity and freedom. So, these laws help, prevent the misuse and profiling of this information for using it further. Then the laws will help prevent misuse by the organizations. Now organizations and businesses tend to collect large amount of data for business efficiency, their analytics, their research and automation. But without a privacy law or without a regulation in place, data may be collected excessively. The data can be used for unrelated or unethical purposes, or it can be shared or sold out in the market without our knowledge. Then, one more reason why I feel privacy data laws are required is to protect against obviously data breaches, because it can expose millions of people to financial laws, identity fraud. So we need to have security safeguards in place through the privacy laws. Then, one of the most important reason is technological advancements. Now we have technologies like AI. You must have seen those trends on Instagram and Meta, wherein we are giving our pictures, and that application is coming out with another pictures, creating a narration of what you have given to the app. So these technologies significantly impact data privacy. So there are devices which are connected to the internet. There are health watches which help you to keep a tab on your health, like they provide with the your BP, your heart rate and all. So what happens is this is actually sending out the patient's data directly to the healthcare providers, and then there are customized billboards being prepared. So again, because of these reasons, there are a lot of concerns due to which these laws have actually come into place. Now, if we talk about the global privacy principles, so basically, this 21st century, as I said, there was a huge surge in data breaches, identity theft. So these developments prompted governments, international organizations, and private sectors to recognize that there is an urgent need for a privacy regulation, because of which initiatives like European Union's General Data Protection Regulation, which we call the GDPR, and the California Consumer Privacy Act, and all other laws, mark the initial steps towards establishing a more robust privacy framework. So, what are these privacy principles? They basically form the core of data protections. Now, these principles have been developed, to create an actual understanding of what is data privacy and to make people aware what are their rights. So these mostly global privacy regimes and laws are based on these privacy principles and general principles, which are quite similar across all the geographies, include lawfulness. Then there should be transparency in what data you are collecting from the customer or sharing. Then you should keep your data minimized, as in only for the purpose for it, minimized as in only what you need, what the data you actually need for that purpose, you have to take it and store it. Then there should be storage limitation, you cannot keep it for forever. Then there is accountability principles, there needs to be someone who must be accountable, who for that data, if there is a data breach in future. Then obviously accuracy, purpose limitation, there should be integrity and confidentiality for the data, there should be proper security safeguards. But these are the global privacy principles. But what about India's privacy principles? What exactly India has considered to be their privacy principles? So let's look at it. So basically, in India also there are nine fundamental privacy principles. So sorry, seven privacy principles, which are based on globally accepted principles, which we discussed earlier. So basically, first is the notice. So every body corporate should have a privacy notice stating about clear and accessible statements of its practices, the type of personal information which is being collected, what is the purpose of collection, what is the disclosure of this information, how it is being done to the third parties, then what are the security practices they are considering. So notice, let's the individual, you know, let's the normal individual make an informed decision whether actually to give their personal information to an entity or not. And if yes, then to what extent? We'll discuss about the notice requirements, what is specified in the DPDB in the coming slides. Then we have the choice and consent. So basically, choice is actually giving options to the data principals, allowing them to make informed decisions on their personal data provided. So whether or not that personal information can be used for a purpose which is extra, or beyond what is required for the delivery of that product, you have to provide that choice to the individual. For example, using of personal information for additional purposes, like organizations sometimes tend to use that personal information for doing analysis, research, or maybe a quality assessment. Then that is going beyond what is actually being provided by the individual for. But if you compare India's privacy principles to the globally accepted or the globally practiced principles, there is quite a lot of difference in it. For example, in India, choice and consent is more business friendly, especially for employment and compliance processing. So, for example, in DPDP, we do have an exception wherein consent is not required if you're collecting data from an employee and using it specifically for the employment purposes, like if you're using it for the payroll, for getting insurance to the that employee, or maybe for applying for the PF and ESI of the employee. So for those cases, a consent is not required. So India is quite business friendly in that way. Then we have the collection limitations. So basically, it says that companies should not collect personal data unless that information is collected for a lawful purpose. Basically, the purpose for which you are collecting should be a lawful one. It cannot be something which is in the first place not given under a law. Then there is a, use limitation. So basically, the information collected should be used only for the purpose for which it is being taken. Basically, that is the purpose limitation. As I said, that you're taking a data for opening an account, but now you are sharing that data to an agency for marketing purpose. That goes beyond the purpose or the use limitation. Then we have the security safeguards. So basically, companies must have a security program and information security policies that have that technical and operational security measures. So in case of a breach, again, if there is a data breach, they must have the capabilities to demonstrate that they have implemented such security measures. Then we have the access and correction principle, basically, which says companies must permit the providers of information to review the information they have provided and correct any personal information or sensitive data. Basically, if I am giving my personal data to a bank now, and but there is a change in that data, so I should have that right to go on their website or whatever application they use and to correct that information if it is incorrect. So basically, some of these principles are in India have been adopted in the DPDP in the form of rights to individual. So again, India offers foundational rights, but fewer advanced rights than the GDPR. For instance, Indian principles do not provide the right to portability. So in GDPR, the individuals have a right to data portability, that they can port their data to, for example, another data fiduciary of the same type. But in India, we don't have this right. Then there is a right to restrict or object to the processing of information. Then we have the right to automated decision making in the GDPR, which is not there in India. Then, lastly, disclosures to third party. So basically, any disclosure to a third party again requires prior permission of the customer. You need a proper consent. So in that way, India again, if you compare it to the global privacy principle, India is more liberal than EU on the data transfers. So, if we summarize, India's DPDPA is globally aligned in principles, but lighter in terms of rights, obligations, and enforcements compared to the GDPR or other international regimes. Because it is, governments, if we take it from the government's point of view, it is designed for digital growth and ease of business, rather than having such a strict regulatory control. Now, moving on to the uh, key your topic of today's presentation, the DPDPA and the DPDP rules 2025. So, I think one of the most important pieces of legislation in the history of India is the Digital Personal Data Protection Act. So, it is a culmination of years of efforts of government, industry, and data privacy experts. So when the Aadhaar came in 2009, there was a huge cry over data privacy concerns. But at that time, UIDI, that is Aadhaar, was a priority. Then again, the Puttaswamy judgment of Supreme Court changed countries' focus to make right to privacy, our right. Then in 2018, there was a committee of experts under the chairmanship of a retired Supreme Court judge, Justice B.N. Sri Krishna, again that was formed. Then in 2019, this bill was accepted by the cabinet, but again it was withdrawn by the Indian government. Finally, the law was passed by both houses of parliament and approved by the president in August 2023. After that, it was notified by the government, and the much awaited draft rules had come in January 25, and finally now in November 2025 the rules have been notified for further implementation. But before we move ahead in our presentation, let's take a quick recap of the DPDPA basics. So we all know what is personal data, or maybe a personally identifiable information. So basically, information that can be used, whether it is a single information or if it is combined with other information, which can help you to identify or contact any particular individual. Basically, it helps you to trace back to an individual. Now, this personal data can be collected, online or offline. It can be a person's name, email ID, mobile number, bank account, photograph, signature, Aadhaar details. There are other uh, identifiers also, which are classified as personal data. For example, a person's IP address, location, navigation data. Then there are cookies, or information which we provide when we fill out certain forms on mobile apps or smart devices. Even this is constituted as a personal data. Now we are giving away a lot of data, especially through our social media posts by liking or reacting to the post. So this is a secondary type of data, which could include things like health data, your religious or political views, or data that reveals your race or ethnicity. This, obviously, in DPDP, we do not have any classification between the sensitive and the general personal data, but this data is actually considered sensitive because it can lead to, that individual's harassment or discrimination, even an identity theft. So again, in the DPDP, there are three very important parties. There is a data principal, who is basically the individual to whom that personal data relates. Then we have the data fiduciary, who is the entity which determines what is the purpose and what are the means of processing personal data. Then we have the data processor, which is an entity that actually processes that personal data. So let's see now, whom does this act apply? Basically, this act applies to the personal data of individual if it is processed within India, or it applies to personal data processed outside India, but if the data relates to service or offerings in India. For example, there is an insurance company in India. It uses financial information of a customer residing in India for policy valuation. Now, here the company is in India, processing is in India, customer is in India. Now, we take a second example. For example, a company like McDonald's. They are collecting customer information abroad for a new marketing campaign, but targeted to Indian customers for a new Happy Meal. So here, even though the processing is taking place outside India, but it is targeted to Indian consumers for Indian products. So the goods and services belong to India here. So again, the DPDPA is applicable here. But there are again scenarios wherein the DPDPA does not apply. For example, where you're just casually giving your opinion on a social media like Instagram, LinkedIn, or maybe you are just chatting with someone on WhatsApp, or taking your friend's number to meet them over dinner. For such personal reasons or domestic uses, the act does not apply. Now, let's go to the key provisions in the DPDPA and the DPDP rules, which are very important for us to actually understand. And we've also stated the changes from the draft rules which were issued earlier. So basically, just to have a comparison of what the draft rule said and what is the final outcome in the final rules. So coming to the privacy notice. So basically, every request, which is made to a data principal, it has to be for consent, has to be accompanied by a notice. This notice has to be given by the data fiduciary to the principal, informing them about what is the personal data, what is the purpose for which it is used, and how can the data principals actually exercise their rights. They have certain rights, as we discussed earlier, and how can they make a complaint to the board and raise their grievances. Now, the recently released rules emphasize on specific description of the purpose rather than an itemized list. That this is because to avoid overly worded notices. Again, a critical requirement notice needs to be clear and simple language and independent. It cannot be hidden or clubbed in the TNCs. Notice has to have a proper mechanism of how it can be withdrawn, and the process of withdrawing again. Consent can be withdrawn, and the process of withdrawing the consent again should be as easy as it is to give the consent. So, again, the critical part, the requirement of a notice also applies if consent has been given before the act has come into place. So, even if this act came into place now, but you've already taken consent a couple of years back, you need to present a notice to the customer informing them about these few obligations. So, therefore, very important elements of privacy notice to summarize. So, assuming if I am looking to access the service of an e-commerce platform, the way a notice needs to technically work out under DPDP is basically my name, my phone number, my address, or my email is something which is required to be itemized, that these details are going to be processed. Next is what exactly is that e-commerce platform, for example, Amazon, going to do with that data. Next aspect is to inform me of basically all the services that the platform is expected to provide to me. So there should be a detailed notice giving specific descriptions of all these information. Now, next, talking about consent. Now, the whole basis for a privacy legislation for the DPDP Act is what is your ground for processing that personal data. Now, this personal data which the company collects can be processed under two scenarios. One is when you obtain consent from individuals, or it falls under the legitimate uses. We'll discuss it in a couple of minutes. Now, for a consent, if you are processing the data basis the consent, you need to ensure that uh, basically consent is where you write to someone, can I process your personal information and can I process it for so and so purposes. Obviously the consent must be freely given, it must be specifically specific, to the point, and it must be unconditional. Okay, it cannot be a kind of give and take relationship, or cannot be something, mandatory. If you do not give me the consent, I'll not let you proceed ahead. It cannot be that way, give and take relationship. And of course, there should be an unambiguous indication of the consent in a clear affirmative action. So basically, you cannot just present the customer pre-tick check boxes and ask them to just go ahead without actually affirming to that consent checkbox for that purpose. So again, this is very similar to the GDPR, except the word unconditional. But of course, GDPR applies very strict standards. Also talking about a consent, very important consent mechanism, which I think lot of people tend to ignore, is cookie consent. Now, almost every organization is going digital. There are websites and applications which are being used for lead generation, sale of products, and all. So basically, these are cookies which are used by the websites, for improving browsing behavior. So basically, these cookies are collecting a unique ID in the form of a name value pair, wherein which is used to identify a particular user. But for all these cookies, again, cookie consent is very important. So organizations that should implement a cookie consent by creating a cookie consent banner, maybe that provides information on why cookies are being collected, as well as an option to opt in or opt out or reject the cookies. Then you need to have a proper breakdown of the cookies as to what are the categories of those cookies. Are they essential, very necessary for the processing, or are they functional, or are they for marketing? You need to give a bifurcation of that. And also, websites that are collecting consent, they need to demonstrate that user has actually given the consent by maintaining proper trails, because again this can be used by the data protection authorities to ask for demonstrating or evidencing the proof of consent collection. Now, as we were discussing earlier, there are some scenarios wherein consent is not required. These are in the act are called as certain legitimate uses. Now, what are these scenarios? Basically, for some purpose for which individual has voluntarily provided their personal data to the fiduciary. For example, you are requesting a real estate broker to provide you with suitable details of some property or a flat, for which you share your personal data. So that is something you voluntarily need. that is for that consent is not required. Then there are cases wherein the person has already consented for a subsidy or a benefit by the government, in which government can process the data to determine eligibility for any other benefit which the government provides to that particular person. Then if the data is being used to fulfill any obligation under any law or a court's order judgment, again consent is not required. Then in case there is a medical emergency, for responding to a medical emergency which has a threat to the life of that data principal, there is a medical treatment, again for that consent is not required. Then there is an interesting legitimate use for employment. So basically, by and large, you don't need to obtain consent wherein it is a situation of employment. So not every purpose for which employer uses personal information may be covered under the scenario. So we may need to check by and large the typical purposes of employment wherein consent is not required. Then moving on to the next provision on children's personal data. Now, when the act came, there was a lot of traction, especially for companies which generally deal with such kind of users, the children at a large scale. So now the rules finally elaborate, stating that fiduciaries need to implement measures to ensure there is a verifiable consent which is obtained from a child's parent. So before processing any personal data, we need to first identify if the user is a child. And if so, the identity and age of the parents must be validated by referencing it to the details, if it is already available with that organization, or that organization can do a due diligence check by you making use of something like a DigiLocker virtual token. Again, the another important obligation is data collection and sharing should be minimized when it comes to personal data of children, and profiling that can allow children to be targeted should be switched off by default by such companies. Uh, again, there are two categories which are specific. There are some categories which are specifically exempted from complying with this law. Obviously, there are certain terms and conditions which they need to comply with. So basically, these are the clinical establishments, the healthcare professionals, educational institutions, childcare entities, basically who are the ones who are processing the data in the interest of the child or the health and safety of the child. And there is also an exemption which is based on the purpose for which the data is being used, which is basically for performance of state functions and all. So, for example, there is a child care center who has hired a transporter for, moving the kid from a child care facility to their home. So, if they are tracking the child's location, that is for the safety of the child, he safely reaches the home. Then in that case, such kind of transporters with whom you have a tie, that those are exempted from complying with these obligations. uh Now, but there are certain challenges in complying with these obligations. Basically, introducing the possibility of entirely substituting the child's, autonomy with that of parent creates unique problem, particularly if there are differences between the parent and the child in relation to consent. See, even if the child is 18-year-old nowadays, the child may disagree to their, parent not giving the consent. I mean, how hard it is for a 18-year-old to get his parents phone and actually approve requests. So this obligation can be overbearing on a lot of data fiduciaries, as they may need to require they may need to verify the age of every single user. And by the interpretation, we can assume that it means that the child has to self declare, and we need to verify what the child is declaring. Because basically, if the child is declaring that he's 19, then we need to actually verify, maybe through an Aadhaar or something, that he's actually 19 years old. So, there is still this rule is again very difficult to comply with. Now, similarly, for as as a children's personal data, we have data of persons with disability. Now, similarly, verifiable consent has to be taken from a lawful guardian, and it would also apply in cases where the user or the person is suffering from any mental or physical impairment, in which case he cannot make a decision, or there are people with mental retardation, autism, or severe multiple disabilities. Again, fiduciaries must have due diligence measures to ensure guardian is validly appointed under the laws related to the guardians. Now, next is the consent manager. So, a consent manager is basically supposed to be an interoperable platform. This is to help the data principals to provide consent. It is quite similar to the account aggregator framework, and it is a regulated activities which now requires pre-authorization from the Data Protection Board. Basically, what is the job of consent manager? It is to help the data principals to give consent for processing data. Now, all the records of consent, which is maybe the consent given, consent denied, consent withdrawn, the notices, this data needs to be maintained by the consent manager, and it should also be made accessible to the customer. So, for example, the same consent for a similar purpose can be used by similar entities. Like we have the concept of a CKYC. This is the meaning of an interoperable platform. Now, the DPDP rules have laid down a formal process for consent managers to apply to the board for registration. Unlike in the draft rules, which just outline the eligibility requirement. Now, the rules have created certain conditions for consent manager, like prohibiting subcontracting. There needs to be record retention for 7 years. You need to have audit mechanism in place. So there are certain changes from the draft rules, because now the consent manager ecosystem has actually moved to a regulatory entity. Now, moving on, data breaches. So, I think in the past few years, we have observed so many data breaches. Like there was this Aadhaar data breach which had happened in 2018. There was a leak observed in, big banks like SBI in 2019. So these data breaches are happening so frequently and affecting so many people. But at present, Indian companies aren't required to notify the consumers of personal data breaches, which actually leaves the individual in dark about what are actually the potential threats. So now the DPDPA comes as a savior. Individuals now have the right to access, correct, update their information. As per the DPDP, now the fiduciaries are actually required to notify a data breach to that individual immediately, including the safety measures taken to protect their interest. Again, here, Rule 7 of the DPDP rules transforms this incident response from just a IT management function into a statutory obligation, making it mandatory for a dual notification to both that effective individual and the data protection board. That too without undue delay. So this is very critical in the event of a data breach, that you are required to go to the affected individual and the data protection board immediately and give certain set of information. And within 72 hours of the breach, a detailed information is required to be presented to the board. But trust me, in 72 hours, organizations can really face an uphill task to provide to the regulator all this information. Another thing is, this is, I think, one of the strictest regimes in Asia, particularly because it requires universal dual notification. Then penalties are also business threatening. But breaches can be of different categories. For example, breaches mean you can have a breach in the form of an unauthorized acquisition, access, or unauthorized disclosure, or maybe, erroneous data sharing, lost devices containing personal data. So, in DPDP, there is no material threshold which has been defined. So, all personal data must be reported. All personal data breaches must be reported. But again, the reporting has a lot of challenges, because without undue delay. That means you have to inform immediately. This means you need to have real-time detection mechanism. There needs to be 24/7 monitoring, automated alerting. Then you need to have pre-approved templates in place. So there is dual pressure on the organizations now. So there is an entire process here that you need to first discover the data breach, you need to investigate and prepare an RNC about it. You need to take measures how to contain the data breach, inform the user and the board, and again recover from it to prevent it occurring in future. So again, for the data breaches, policies and SOPs need to be in place for the containment procedures, escalation matrix. So then the act also mentions that the board can inquire about, the timeline of events, logs, evidences of containment. So I think if you talk industry wise, I feel industries like fintech and BFSI, which process high risk data like KYC documents, financial transactions, or maybe an healthcare industry which processes medical data, they are having large scale databases. This can have a lot of impact from the data breach management provision. Next up is the data retention provisions. So basically, this is one of the most underestimated aspects of the DPDP. So retention and deletion were, primarily IT housekeeping tasks. Under the DPDP, they are now legal obligations. They are so one of the rights which have been passed on to the individuals, which I'll press upon, is the right to erasure of personal data. And fiduciaries, are obligated to erase all personal data upon occurrence of two events. First, where there is a consent given and the consent is withdrawn by the data principal, and where the specific purpose, second event is where the specific purpose for which the data was collected is now no longer being served. So basically, Section 8 of the Act requires that you need to erase the companies need to erase the personal data of individuals as long as it is, we can assume that the purpose for which the data was collected is no longer be served, or, it is not required under any law. So this calls for a major shift from legacy IT practices where, data was often retained indefinitely. Under the DPDP Act, indefinite retention is unlawful unless it is required under any uh, statutory obligation. So here the DPDP rules, the Rule 8 gives an operational framework and explains that data retention can be only till the purpose for it is seen to be fulfilled. It also says that, data can be deleted only after you give a proper notice to that individual, and that notice should be before 48 hours of the deletion. So this means that there must be automated decision workflows. So also if you provide a notice, 48-hour notice to that individual, and he have bounced messages or undelivered notices, again, record of that needs to be maintained. Okay. So interestingly, there are certain regulatory purposes for which the personal data and associated traffic data has been mandated to be retained for a year. So this means that logs must document access events, consent withdrawals, deletion triggers, and so there are certain regulatory purposes. So for which the DPB, the board may ask you to retain it for a year, because that data can be helpful during investigations to access whether there is who accessed the data log, and what are the security obligations complied. So for those purposes you need to maintain it for 1 year. Apart from that, there are certain data fiduciaries for which retention requirement has been specified. For example, the high volume data fiduciaries which have been called out, like an e-commerce entity, there are online gaming intermediaries, there are social media intermediaries. So each of these expressions have been defined, and the period which is being given for retention is basically 3 years from the date the data principal actually approached in that entity, or maybe they have withdrawn their consent, whichever is later. So these entities may be mandated to retain the data for longer period. This is particularly why these entities have been called out, is to manage fraud detection, dispute resolution, audits because of the huge data volume which they hold. Now, why is retention and deletion more complex than they actually appear? This is because now companies are storing data across multiple cloud regions. They are using backups, collaborative tools, they're using SaaS systems. So, deletion in one system does not guarantee deletion everywhere. So this is a huge, catch and difficult task to maintain the retention and deletion process. Again, due to the conflicting laws, because in India, there are certain sectoral laws which impose retention requirements. Like for RBI, data is required to be retained for 5 to 10 years. Then SEBI specifies 8 years. Companies Act, there is a different timeline of 8 years. So companies now need to create a retention matrix mapping DPDP rules against the sectoral laws as well. Moving on to the significant data fiduciaries. So basically, these are specific class of data fiduciaries. They are based on their uh, volume of personal data process, the sensitivity of the data process. So it can be if an organization is maintaining health records, biometrics, financial information, or if there is any data which in scenario, but if it is leaked, then it may it may have a risk of harm to the data principal, for example, through profiling. Then the other factors, like if a organization is you completely dependent on AI technologies. So in essence, basically an SDF is a high stakes data handler whose operations can have a significant impact on that user's privacy. So these SDFs will be notified by the government, and they'll have to comply with certain additional obligations like an annual DPIA. So basically, DPIA is the Data Protection Impact Assessment, which is an additional obligation that every SDF needs to comply with. And so basically, what is this DPIA? It is used to review how the personal data is processed in that entity, and it will help identify the risk and impact of the personal data being processed. So obviously the individual who is doing the DPIA, they have to submit a report with key observations to the Data Protection Board. Then there'll be independent audits which are required to be carried out in every year. Then we have the Data Protection Officer requirement. Basically, every SDF has to designate a data protection who shall have specific duties. So they are the one point contact for the regulator and the individual. Then the data protection officer needs to be based in India, and they are the first point contact for complaints and grievances. Then we have the algorithmic accountability measures. So basically, an SDF, if they are using tools and algorithmic systems for sharing, modifying, or transmitting personal data, they need to ensure that if that system is using an algorithm, for example, a recommendation engine on a social media, they have to ensure that the outcome is not unfair, that is, the personal data is not being misused, and these AI decision engines, etc., do not they are not causing any adverse impact on the data, on the rights of the data principles. Next is there is a restriction on cross-border data transfer of certain data. Now, this is a very interesting point. So, which I would like to highlight is basically there is a data localization requirement and restriction for transferability of some kind of personal data. Basically, not all the personal data, but there are some classes of personal data which cannot be transferred outside India. So again, this again will be determined by the central government through a committee to specify what exactly is this personal data. And maybe we are expecting a clarification from the government soon on what exactly is this data. Now, moving on to the cross-border data transfers. So, what is a cross-border data transfer? Basically, if the processing of personal data of individuals in India is being done from any other country. So this processing can happen through, manual means or automated means, and it includes, all types of processing. It can be sharing, disclosing, whether if it is in a cloud or a non-cloud environment. Now, DPDP has certain restrictions on cross-border data transfer. Now, organizations can transfer personal data outside India only if it is a government notification. So, the government can impose, restrictions on transferring the data to specified countries or territories outside India. So, basically, they'll give a negative list of countries to whom you cannot transfer the data. This negative list will be, basis and it will be basis assessment of various factors. So central government has right now retained the power to notify these restrictions. This again is something that we have alluded that where data fiduciaries could face a lot of challenges, and especially ones who are processing data in India for customers based outside India, because again they'll have to reconcile it with the foreign laws. Next is there are certain exempted categories. So basically certain categories of processing are exempt from the government notification requirement, which includes, if the processing is necessary for enforcing a legal rights or claims, if the processing is recommended or mandated by courts, regulatory bodies in India, then if it is necessary for your detection of legal offenses, or if it is under a merger amalgamation. So again for these cases it is allowed and exempted. Now, here the process which needs to be followed by the organization is they need to ensure to notify the data principal in detail before the commencement of data transfer outside India. And the agreements basically which they have with their data principals should provide with a detailed privacy notices before the data transfers. Then the agreement should, as I said, be executed properly. But again, DPDPA does not override certain sector specific laws which are already there in India for cross border data transfer. For example, because the act says that if another law in India has stricter rules, the other law will take precedence over the DPDP Act. Now, several Indian laws impose stricter data localization requirement across various sectors. For example, RBI. So RBI mandates all customer data, related to payments to be stored exclusively in India, except for certain transactions that have a component outside India. So again, IRDI for insurance that mandates all the policy records to be maintained in India. Then SEBI again has a framework issued for cloud services request. Basically, again, it says that for SaaS services, the information needs to be stored in India. Then again, Companies Act states that details of all the books of accounts and financial statements have to be maintained at the registered offices. So even if a certain data transfer is permitted under the DPDP, the transfer cannot take place if a different law prohibits it. So as I said, the other law will take precedence in this case. Next is the data principal rights. So this is a less contentious aspect. So let's quickly discuss what these rights are. Basically, first is the right to access. So data principals again have a right to seek all the information that has been taken from them by the data fiduciaries or the processor. So you can request a summary of your personal data, the purpose of processing, and who has access to it. So, for example, you signed up for an online shopping platform like Myntra, and you want to know what is the personal data that they have collected. So you submit a request on that platform asking for a summary of your personal data, including your name, address, etc., and who has access to it. So the platform will provide you with a detailed report of your data. So this is the right to access. Then we have the right to correction. So basically, you can request corrections if the data is inaccurate. For example, CIBIL report or any credit report which contains an error in their employment in your employment history. So you can contact the credit bureau to correct that information. Then we have the right to erasure. So you can request the deletion of your personal data when it is no longer necessary. So, for example, a job portal like a Naukri.com, wherein you had applied earlier, but you have already got a job, and that portal still has your resume and personal details, even though you're not no longer job hunting. So you can request the portal to delete your resume with the help of this right. Then you have the right to nominate. So basically, if you're traveling abroad and you want someone to actually manage your data rights in your absence, you can nominate a family member to exercise these rights. Then we have right to grievance redressal. You can raise concerns about how your data is being handled. So like you suspect a company of selling your personal data to third parties without your consent, you can file a grievance with that company's DPO. Then company will have to investigate. So these rules also explain now how these rights need to be exercised and what measures do fiduciaries and consent managers need to adopt. So they are required to publish on their website or apps on how data principals can actually access these rights. And similarly for grievance redressal also, there needs to be a timeline which needs to be disclosed within which that dispute that grievance has to be responded to. So basically that timeline has now been defined as 90 days. In the earlier rules it was not defined. So these are the certain rights, but why are these rights important? Because DPDP isn't just about protecting your data, it's about giving you a control. This is the reason why the act and the rules came in the first place, to have, you're no longer in dark about the data you use or your data is used, and you have control on your information, and because of which it creates a trust factor between you and the company who is using your uh, personal data. Next is the reasonable security safeguards. So basically, this is very, very important from a business perspective. So when the rules came up and the final rules, of course, came now, industry was expecting an ISO-like standard to be called out. The good and bad part is that there is no specific standard which has been called out under the rules, but they have given certain standard practices, which are mentioned. As you can see, there is concept of virtual token, encryption, masking, and all. So when we say secure your personal data, it means uh, every data element, that could directly or indirectly identify an individual has to be protected through some practices. So basically, this is the first and fundamental line of defense against data breaches. For example, you have technique like an encryption, wherein you actually convert your data into an unreadable format using a key. You have those masking techniques which partially hides or replaces data to limit exposure, like how we do for Aadhaar, storing Aadhaar. Then we have tokenizations, which replaces sensitive data with a a kind of a token number. Then we have techniques like pseudonymization, which are replacing the actual identifier with artificial identifiers. So these are some of the data security measures. We also need to have access control in place. So basically, only an authorized personnel should have access to that system which is storing or processing the personal data. And this access must align with the role given to that individual. So this can be done, using role-based access control or a multi-factor authentication. Then we need to have visibility on the who is accessing the personal data. This means that whoever is reading, modifying, sharing, or deleting that personal data, the record of that person must be, we need to record it, we need to analyze it and review. Also, the access logs must be, stored in a secure environment. There should be a regular review of alerts which are generated for such high risk data. Then business continuity. So basically, if personal data becomes unavailable through, if there is a system, if kind of a ransomware attack or system is hacked, so we need to ensure that business, there is a continuity through backups. And again, lastly, the security, there should be proper security clauses in the contracts which we have with third parties. So even if the third party is, processing the personal data, data fiduciary remains largely responsible for compliance. So contracts must explicitly define the processor's duties, like the processor should implement proper security controls. There must be immediate notification. There should be restrictions on processing and sub-processing. So again, data fiduciary or the processors cannot retain the data longer, any longer for the purpose for which it is not actually required. But the law has specified that there needs to be access control data needs to be maintained for 1 year to help, us to help the authority with, if there is suppose any incident which has happened, it will help in detecting the access logs, who had access to it and who had, unauthorizingly accessed it. So that requirement has been specified for a year. Now, these were the certain key important, compliance parameters which we shared. Now let's look at the enforcement timelines. Basically, the final rules have come in since 14th of November, and the final version introduces a kind of a structured implementation plans, which is actually divided into three groups. So basically, there is a requirement of immediate commencement for rules 1, 2, and 17 to 21, which is related to governance and institutional provisions, like dealing with the formation of data protection board composition. So these are effective from 13th of November 2025. So the rule 1 provides, timelines. Rule 2 is on some definitions, and rule 17 to 21 is on operationalizing the data protection board. Okay, so there is a 1 year waiting period before Rule 4 on consent manager system becomes effective. That is 13th of November 2026. So basically, the consent manager framework, which introduces mandatory registration for consent managers for facilitating consent, is applicable from 13th of November 2026. And for all other substantive obligation rules, there is an 18-month timeline which has been specified, which is 13th of May 2027. So this substantive obligations include, all obligations affecting daily operations like privacy notices. There is children's data processing, SDF responsibility, data protection rights, cross-border data transfers. So all these are effective from 13th of May 2027. Uh, Privacy in organizations. So we discussed about the key provisions of the act and the rules, and why is actually data privacy law taking so much importance, and why are all the countries acting upon it. So data privacy can actually make or break an organization. So when a user gives business their information, there is an element of trust that acts as the foundation of that transaction. So, beyond the goods and services or the money, the trust is a company's most valuable asset. But a lot of companies from the SMEs to multinationals, stumble when maintaining this trust and protecting customer information. But why does this happen? What we have observed is there are certain mistakes or areas where most organizations fail when it comes to data privacy. If we have a look at this, first and the foremost is data mapping paralysis. So most organizations don't fail at privacy because of any malicious intent. They fail because of what they cannot see. Unstructured data is at the center of this problem. Basically, what happens is personal data gets scattered across the organization in the emails, shared folders, backups, cloud environments, or outside any visibility. So it is very important to actually have a clear visibility where is your personal data actually residing. So during, in 2026, I feel more companies will use AI based discovery systems to remove these gaps and actually map their data. Then there is absence of consent infrastructure. So consent forms remains the main rule here, but managing it across large environments is very difficult. Consent, needs to be informed, clear for each purpose. It has to be easy to withdraw and recorded. But what happens is existing consents are very vague. They are bundled with each other and they are very complex. Also, the consent withdrawal mechanism is either non existent or hidden in the terms and conditions. So, a practical way forward is to have a unified consent system that actually captures and updates consent in real time and keep audit records that can be checked, without delay. Then the one important area is unpreparedness for managing incidents or a breach. So basically, now the Act says there needs to be a 72-hour notification for immediately informing the board for informing the board. And there should be an immediate notification as well. Practically, this 72-hour reporting expectation is similar to global regulations. Yet, most enterprises are struggling with the both detection and coordinated response. So, most organizations lack, they don't have a documented incident response policy or procedure in place, leaving them, vulnerable to. Uh, they have to extend the timelines, or there are delays in investigations. They are not able to identify the root cause because, in the first place, they did not have the breach management process in place. Next is the children's data processes. Of course, most organizations don't differentiate between an individual who is an adult or a child. Verifiable parents mechanisms don't exist. So basically, if you're offering any product which serves users who is under 18, and you don't have the children's process to identify a child or verify the parents' age, so you are operating outside compliance. Then next is weak vendor management. So basically, a large share of issues which we'll see in 2026 will come from third party systems. So, because data processors right now aren't contractually bound to the privacy obligations, there are a lot of sub processors whose relationships are not documented. And here, the risk keeps escalating because the third party or the vendors cannot often handle personal data without aligning proper DPDP safeguards. Then the agreements which we maintain may lack technical clarity. So this has makes the vendor management a very weak link. Then lack of privacy culture. So data privacy is not solely the responsibility of the legal or IT department. Most data leaks can occur internally, though may not be through cyber attacks or hacks. So to counter this, it is very important that data privacy needs to be ingrained in an organization's culture as much as a part of its DNA. Then there is a lack of C-level involvement. So what happens is data privacy policies is required to be maintained from the top. So without the support of senior management, any data privacy efforts will likely be ineffective or or it can be short-lived. Now, senior management is actually responsible for driving this entire conversation of data privacy embedment within their organization and educating the employees on what is the importance of data privacy. Then, lastly, treating compliance as a checklist item. So, most companies make this mistake of treating, data privacy compliance as a one-time task to be checked off a list. But it should not be viewed as merely a tick box exercise, but it is an ongoing commitment to protect the personal data. Uh, Now, let's talk about how AI is, what is the role of AI in data privacy? So basically, AI has become such a powerful enabler and a challenge for data privacy. But why AI matters a lot is because of such a huge digital transformation. Now the DPDP Act has come into place. There are global privacy expectations. So it is not just a technology layer. It is also becoming a privacy management tool. But how does AI actually support data privacy? AI and privacy can go quite well with each other. And of late, there are a lot of AI tools being used for data privacy compliances, like for data mapping or discovering where actually is the data residing in an organization. We have data discovery tools. So basically, AI helps to automatically identify the personal data in an organization. Where is it residing? Which can help in actually in making it supporting DPDP requirements of purpose limitation and data minimization. Then AI is also used for privacy risk assessment. So basically, it analyzes how is the data flowing across systems, which helps in identifying what are the high risk processing activities, where is unauthorized access being done, or where are the risk actually in a security risk. Then anonymization and de-identification. So as we touched upon the security safeguards which organizations need to have. So AI improves techniques like mask. AI monitors behavior patterns to detect anomalies. So it helps in enforcing. So it helps enforcing privilege accesses and preventing insider threats. Then we have the data breach detection. So AI is also used a lot in actually detecting real-time detecting logs and network behavior, user action, which helps in identifying any data breach. But why is AI so risky even, or if we are using it as privacy tools for privacy compliance? Because if an AI model is using personal data during training, they may unintentionally reveal it because there is no accountability or transparency in it when we use an AI. So there are risk of re-identification, and AI can memorize those sensitive patterns which we give. Then AI may actually generate incorrect information about a person. It can misinterpret privacy policies or give wrong compliance advice. After all, it is not a human. So this makes human oversight quite essential. Then there can be excessive data processing. It can collect more data than needed, or which it violates the core privacy principle of data minimization and purpose limitation. Then AI models can manipulate personal data. So high risk automated decision making requires human intervention. There needs to be transparency, which AI systems currently does not have. So I feel, though AI is a powerful privacy enabler, but it cannot be a standalone solution. So there needs to be automation can happen only if there is accountability and transparency in the compliances. So next, just- lastly, journey to compliance. So basically, businesses that process personal data improperly, have a high chance of facing a lot of risk. There can be reputation and trust deteriorations because of data incidents, fines by regulator. Then operational complexity can happen because it is no longer sufficient to have just a privacy policy on the website. You need processes, you need consent capture mechanisms. Then, under the new rules, consent must be free. There are detailed requirements. Then, there are strict regulations on cross-border transfer. So there are a lot of compliances which need to be ensured, because of which there you need to align your data practices with the acts and rules requirement, which is very crucial now. So maintaining compliance with evolving regulatory standards and shifting, from reactive to a proactive data governance is very important. Firstly, to maintain it in the coming future, to have a compliant DPDP process or a culture in your organization, you need to start with visibility mapping, basically keeping a track of personal data that is being collected, processed and stored across your organization, be it in plans, offices, IT systems. There needs to be detailed exercise to understand the state of personal information in your organization. There needs to be a comprehensive privacy program which integrates governance, risk management, and compliance across all processing activities. So we need to have policies and documentations in place. This includes website policy and a cookie policy. Again, their privacy notice and consent mechanism is very crucial, and we need to have the framework design and privacy notices in place to process the personal data. Then, security, data privacy and data security are closely intertwined. So, organizations need to have proper security controls in place. And to achieve these security measures, it is very important that senior management as well as employees needs to be made aware, you know, and then there is a proper training and vendor contracts are properly defined. Incident response and breach readiness, to manage privacy incidents or data breaches, a formal process needs to be in place for reporting of data breaches to the board as well as the principal. Action to be taken to strengthen the controls, and that breach does not happen in future. Then we need to have proper procedures for enabling the organizations to actually give data the rights to the data principles, all the rights which are defined in the act. And again, the response workflows across all the departments need to be defined. So I think that is it from my side. So, while organizations have so far prepared to wait till the publication of final rules, the DPDP Act now being enforced with a definitive timeline, I think it is very important for organizations to initiate and expedite with the, compliances ahead, which are going to be implemented now. Yeah.
Thank you so much. It was really a great presentation. Told us a great deal about the Data Protection Act and how the journey ahead is going to be. Uh, I've got
Thank you.
some long and some quick questions for you, and there are some which are asked by the audience. We'll start with the bigger picture and policy level questions. You may give a terse or a very crisp answer, or you may take some time and explain them with your own inputs. How does the DPDP Act balance individual privacy rights with India's digital first governance and ease of doing business objectives?
Uh, so I think the act, makes a special consent. Firstly, the consent, an informed and explicit consent, the pillar of a lawful data processing. Then there are certain rights provided to individuals, which empowers citizens for having a greater control over their digital identity and aligning it with the constitutional rights recognized under Article 21 of our Constitution. Again, the regulatory architecture, which the DPDP has, specified that there should be a data protection board where citizens can file their complaint, track grievances. I think all this will actually help in achieving what the DPDP was defined to do, to give a digital first governance. And again, there is a 18-month phased compliance window, which for the businesses ease also helps the business to implement systems and processes gradually in a phased timeline. So I think this will again balance what the government has actually planned, and also the businesses processes to align it with the law.
Okay. In what ways does the DPDP framework depart from GDPR, and where has India consciously chosen a different regulatory philosophy? If you could just tell us a few points where
Yeah.
our indigenous law is different from GDPR.
So India's DPDP actually borrows a lot of ideas from the European Union's GDPR, but it also consciously departs from a lot of in a lot of ways. Like GDPR has a very compliance heavy model, and in India it is very lighter governance and growth oriented way. In DPDP, so for example, consent is the default rule with limited and clearly defined legitimate uses. For example, if you can take a consent or certain legitimate uses, like if it has to be data has to be used under any law. There is no open-ended legitimate interest grounds for private entities, like unlike GDPR. So GDPR has a lot of processing grounds, which is not there in India's DPDP. India's DPDP is quite restricted in that sense. Then, unlike GDPR, which applies to all personal data, the DPDP covers only digital personal data, which aligns it with the digital friendly regulation.
Okay. And taking a cue from your answer, given the wide scope of legitimate uses under Section
Yeah.
7 of the new Act, uh, is India moving towards a post consent privacy framework?
Uh, I don't think fully. Uh, India, not maybe for post consent framework may not be for all, but India is definitely moving toward a more selective state led post consent framework. So basically, post consent is not there across the board.
Okay.
It is there are certain legitimate uses, coming out of statutory purposes, government necessity, medical emergency, wherein consent is not required. But for the private sector or other businesses, consent remains by default, and there is no open-ended legitimate interest clauses here. So I don't feel completely, but yeah, for certain selective classes like the state-led entities, it is going to a post-consent framework.
Okay, thank you so much. What are the most common consent related compliance failures you foresee, or you have experienced in terms of your wide array of reading of global cases? What are the possible problems do you see in this consent related compliance framework?
Uh, so I think enforcement action from the authority DPB is likely to arise not from the data sharing or cross-border issues, but from basic and repeated failures in how basic consent is designed or how it is recorded. So basically, usual errors can be, it can be the privacy notices which are supposed to be accompanied with the consent. They can be in very dense legal and technical language. Then there can be either a blanket or a multi-purpose consent. So then there can be, mistakes by the organizations in failing to record the consent logs, or they are not able to demonstrate how the consent was actually taken. Then there can be scenarios when organizations are making consent compulsory for certain data which not required, actually, wherein the consent is not required, or maybe the reverse of it. So entities assuming broad exemptions apply to them. So these are certain operational issues where I foresee that consent related compliance failures can happen the most.
And how should one? I'm just adding on to the line of consent because your answers are giving rise to more questions. Um,
Okay.
these and these issues are very important, because you've just mentioned that consent is maybe the heart of this
Yeah.
DPD. That's what my takeaway is from your presentation. That consent is at the bedrock of it. So, how should organizations practically manage withdrawal of consent without disrupting ongoing contractual or statutory obligations?
So, I don't think withdrawing consent will require stopping all other data processing.
Okay.
Firstly, organizations should actually distinguish, be able to differentiate between, you know, data, as I said, for what data do you actually need a consent, and for what data it falls under legitimate uses. So,
Okay.
they should stop what is optional and continue what is mandatory. So, for the purposes for which it is mandatorily required, that needs to be taken. And if you follow
Okay.
the purpose limitation or the need limitation, the personal data which actually is not required in the first place should not be collected at all. This helps with narrowing the data use and not disrupting the core operations altogether.
Okay, so you're saying that there could be a via media that one does not need to disrupt the contractual or statutory obligations or the relationship itself while withdrawing the consent, or could be a partial withdrawal of consent when there is an arrangement where multi-layered personal data is being used. One may withdraw it for certain aspect and keep it for certain aspect. Is that what you're indicating at?
Yeah, firstly, the data mapping and what is the data, personal data actually being used for.
Okay.
That purpose classification is necessary to actually see for what do you need a consent and you do not need a consent. So that is the first step in identifying.
And where does in all of this the burden of proof of consent lies? Let me just make my questions more clearer. With the burden of proof of consent placed on data fiduciary, what kind of documentation and systems are expected to withstand the regulatory scrutiny? And also give us a little insight on how do you think enforcement in this area may become tricky?
So here in the DPDP Act, the burden of proving a valid consent lies on the data fiduciary.
Okay.
So if there in future there is a scrutiny or an investigation by the Data Protection Board, organizations will need credible evidence to actually prove to demonstrate that they had taken consent. Now this evidence can be in the form of detailed consent, even logs, privacy notices, but the versioned copies.
Okay.
Then, as I said earlier, there has to be a purpose specific consent mapping. Like for this purpose, I'm taking a consent. And there has to be record showing that consent was freely given. It was not actually bundled or, just pre-ticked and deemed consent. So, uh, regulatory scrutiny, will focus less on policies and more on whether an organization's technical systems can precisely, reconstruct what a user consented to, and when did he consent to, what was the purpose for which it consented to. So if consent cannot be demonstrated properly through logs and controls, it will
Okay.
be treated as invalid. So just by certain policies or piece of papers, you cannot prove consent. You need to have proper systems in place, and that responsibility lies completely with the fiduciary.
Okay, so you're saying that paperwork will not supplant the practical procedures that are being followed on the ground. Like if I take the analogical example, in
Yeah.
PIT regulations, SEBI mandates drawing up of a detailed code of conduct, and equally there is also a special emphasis on having internal control systems which are functioning. For example, take structured digital database where logs and everything need to be maintained,
Mhm.
entries need to be done real time or as soon
Yeah.
as the UPSI travels. So I mean, if I take an example, like in a PIT insider trading investigation, when SEBI is trying to find out when UPSI took birth and when it died down, they are not satisfied with only paperwork, but they also see what are the on-ground steps taken for ensuring the timely recording of UPSI and its dissemination and throughout its life journey. You're indicating that I mean, the investigation will focus on the practical on-ground steps taken by the data fiduciaries, not merely what they have written on the piece of paper and displayed on their websites or through other modes.
Yeah, because there can be, see, at the end, compliance needs to be in spirit and not on paper.
Okay.
And you may be having a lot of policies on your website or maybe in your organization, but if you do not have processes or controls to follow it, then there is no point of maintaining those policies in the first place. So there needs to be technical, proper, reliable records to prove whenever you're taking a consent or maybe the client is, individual is withdrawing the consent.
Now, in that context, how transformative do you think is the concept of a consent manager becomes, especially for the data governance ecosystem, especially in banking, fintech, and health sector, because these sectors prima facie deals with a hell lot of personal data of people and very sensitive personal data, something that may cause real loss to people and breach very deep and maybe irreparably into the privacy of individuals.
So, in the sectors which you highlighted, like the banking sector or the fintech sector, the personal data, as you said, they maintain enormous, huge personal data, and there is also sensitive information like they maintain the KYC documents, the financial transaction details of the customers. So, and considering the size and operations of of such entities, I think consent managers could be, a potentially very transformative layer here across these institutions, because they will help with they'll help the similar entities with interoperable consent across institutions.
Okay.
So in fintech, we already have the account aggregator model, which has, shown a lot of efficiency. Even if we get the consent manager aboard for the health, it will, help patient individuals like the patients to maintain their sensitive data across data providers.
Okay.
So basically, consent manager is just like an account aggregator framework,
Mhm.
and it can be just like we use a CKYC, like how if we do a CKYC now, it can help other bank to use the same document. Same
Right.
is the work of a consent manager. So it gives power to the users, and also it is concept is very, helps to, operational, and it is a very critical infrastructure under the DPDP regime.
Okay. Do you want to give portend the future or do you anticipate, for lack of better words, that these consent managers may become mandatory in certain sectors in coming future? Let's for example, health sector or finance or banking. Do you anticipate any such change? Because right now, if I'm please correct me, are they optional or mandatory as of yet?
So as of now, consent managers are completely optional.
Okay.
But I think consent managers could become mandatory, in high data risk sectors, like you mentioned. There are banking, fintech, then there are telecom or e-commerce platforms and health. So these industries, these platforms maintain huge personal data. So even though currently the DPDP Act keeps them optional, but in future, then maybe notification which can be issued by the government or the DPD, which may require them to use a scalable platform, and these entities, it will help them to reduce the compliance burdens,
Okay.
and give have a proper control over the sensitive data. So
Okay.
I think mandatory adoption for certain entities would help giving a standardized, approach to the consent managers, and it is very important in such critical data ecosystems.
Now let us come to a very important uh, aspect that this law deals with, which is not only relevant today, but is also for the future of our country and future of our society, in both in terms of the moral values as well as the conscience of society. And this is pertaining to children's data and vulnerable persons. Um, are the restrictions on tracking, behavioral monitoring, and targeted advertising of children particularly practically enforceable in today's digital platforms?
Uh, I feel that see, this restriction is very well required, because right now you might have seen a lot of children are using social media platform. They are using applications in their schools, colleges for managing their academics. So enforcing restrictions on such tracking and monitoring is very much required, though it is technically challenging, but it is feasible. Uh, all it needs is you need to have a proper age verification and parental consent mechanism. Now the act has also rules have also clearly specified, how such a verification mechanism can be put in place.
Okay.
Then there can be platform level controls to block profiling and tracking. It can be done through automated compliance check. Then of course, if there is a strict oversight on it by the DPP and stricter penalties, then it is possible, though it may be a bit challenging, but it is possible with strong governance and consent infrastructure.
If you have to name three sectors or three type of platforms, please understand the sector in terms of the kind of work they do. What those three models would be, or sectors would be, or industries would be, which need to realign their business model to comply with children specific obligations under DPDP rule. You may name more, but at least three.
Firstly, I think it is the social media platform. I
Okay.
think there are some entities which, in the act also, it has been specifically called out, like the social media platform, the e-commerce entity, the online gaming entities.
Okay.
So I think these are the platforms which are currently being the edtech platforms also.
Okay.
Like I said, the
So
children are using
EdTech, gaming,
uh,
social media, e-commerce.
e-commerce and edtech platforms.
Okay.
Basically, educational apps which are provided by classes and colleges for academic purposes.
Okay.
So I
But
think
how do you
here
think? Yes.
uh,
Sorry.
there is a lot of realignment which may be needed, because at present there is no concept of data minimization, because a lot of data is being collected. Again, they need to implement age gating, that is below 18. If they need to provide it to the children, then it has to be basis verifiable consent. Then there needs to be some default privacy protective settings. Data retention limits needs to be defined.
Okay.
So basically, they have to shift from an ad-driven monetization model, to comply with the DPDP children-specific obligation.
Okay. Now coming to the practical side of it, for those in audience who want to benefit from your opinions, independent opinions on what they should be focusing on in this preparatory phase. For lack of better words, I call this phase a preparatory phase, although the bus is already moving, and those who have not started yet, I mean, in my humble opinion, they are already delayed to brace themselves for compliance and what is going to come. It's almost a Herculean, going to be some at least some, not all, are going to face it Herculean to comply with the kind of governance requirements and internal control systems this law requires them to erect. What compliance areas should the organizations prioritize in the first phase of the implementation of law, or to not falter at the very first level, and to reduce regulatory penalty and exposure? What would be those, let's say, 5 point that you would give to those who are in audience today, or those who would hear this or listen to you at a later day, uh, so that they will benefit from a strategic preparation, not just a helter-skelter, panic-driven preparation to comply with the law, but a strategic preparation in which they will move in a logical order to first prepare the base and then build the building blocks on that.
So, firstly, I feel from a governance point of view, the board and senior management should, treat data protection compliance as a governance issue, rather than making it a law that we need to comply with. So basically, there needs to be an integration of data protection compliances into the corporate strategy at the first level, then in the operational practices, rather than viewing it solely as a checkbox approach. So in the first, in the coming months, I think organizations should prioritize firstly is the data mapping exercise. So it is very important to identify where is the personal data or the critical data residing, because currently a lot of problems happen when the organizations don't have a visibility on their data. Next is the consent management. So the consent collection, withdrawal mechanism, audit logs, the entire consent management framework needs to be in place. Then, if we talk about the data privacy principle, in the first place, data minimization and purpose limitation has to be followed. That is, you only take the data which is necessary, okay, for your particular purpose. Then implementing, baseline security standards is again very important.
Hmm.
You need to bring a strong grievance redressal mechanism in place, and obviously uh, start with spreading awareness on the DPDP obligations across teams to make the entire organization aware what exactly is the DPDT, what are the consequences of non-compliance and penalties.
Okay, wonderful. Uh, do you think absence of criminal penalties um, would provide adequate deterrence only by way of monetary penalties? Because I did not see, and please correct, because unlike you, I'm not an expert in this law. So, do you think there is a chance of prosecution in DPDP Act? There is a provision that may lead to prosecution?
So, I think monetary penalties under the DPDP, of course, it ranges from 50 crores to 250 crores. This, will at the face of it, organizations that it gives a huge, significant discouragement, especially for large organizations handling,
Mm.
such a big amount of data. But it may be less effective for smaller players or repeat offenders. So Obviously, adequate, deterrence also depends on public disclosure of violations. Then there is reputational risk and other regulatory enforcement, not just fines.
Okay.
So I think the monetary penalty level of monetary penalty is so huge and also in the DPDP there is a provision to make appeals and there is an appellate tribunal. There is a proper process of appellate tribunal
Okay.
and making appeals, which makes it the process quite adequate. Obviously, this law is very new. And the government is also constantly refining it through notifications, and maybe in future we expect more detailed clarity to come in place for this.
But let's suppose I'm just giving my views on this. Let's suppose data fiduciary collects data from data principals in an illegal manner, or misappropriates the data, or commits offenses that are captured in other laws, for example, IT Act, which is stealing or misappropriating data unauthorizedly, or committing acts within other criminal statutes. They may still face liability, criminal liability there. And the kind of penalties that you are telling me, um, you know, on the face of it, they are enough to wipe these businesses from the face of commercial landscape. Many of them. These are those kind of penalties. So yes, I think it was a question raised by somebody. I think the law does provide for adequate deterrence. It need not to be only in terms of imprisonment or prosecution. Um, Monetary penalties are certainly deterring in this, and so far as criminal consequences are concerned, there is no immunity. Neither there is any provision which says that these would only lead to civil consequences. Without prejudice to criminal consequences, there are penalties. So there could be, if the elements of offenses are met,
Yeah.
there could be prosecutions as well, read with some other provisions, maybe BNSS, BNS, read with DPDP Act. Now, coming very quickly to the future outlook and industry readiness. What does your hunch say? Because you must have been talking to a lot of people in the industry. They must be coming to you for guidance. What do you think is the level of readiness? Number one. And the second part of my question is, where do you think is the approach may be misdirected in managing this, what we may say, gargantuan compliance requirement that is about to fall on the heads of Indian corporates?
So, uh, see, there are two parts to it. Talking about readiness, a lot of companies who have a presence in EU or other international countries, some of the companies who have a presence, so they already have certain level of compliances in place, which actually complies with the GDPR law or a CCPPA in the California.
Okay.
But again, talking about those companies, they need to align it with the DPDP, because DPDP differs a lot from the GDPR in a lot ways, like the grounds of processing, then the consent framework, the children's, data verification and all. So again, even if they are following GDPR or any other law, they need to be aligned with the DPDP. And but if we talk about companies, organizations who have solely their presence in India, I see a lot of companies, even they don't even have a privacy policy on website. Even such basic things like privacy policy or a website policy is not in place. So I think though the government has given a timeline of 18 months for a compliance, it is very important to align it and map it in such a way that we are able to implement it in a phased manner. If we go hopscotch with the entire process, then it may not be easy even with the 18-month phased compliance window. because there need to be stepwise implementation on it. You need to identify the personal data residence point first, then you need to build the lawful purpose, do the lawful purpose mapping. So again, that it needs to work in a very structured, organized way.
It's 6 o'clock.
Okay. So there are two more questions, and thereafter, I think I'll ask you a concluding remark.
Yeah.
Somebody has asked, what is the impact of this act on company secretaries, particularly in relation to safeguarding the personal data of shareholders and directors? What specific actions are required from the secretarial function to ensure compliance?
So basically, first to clarify, the DPDP applies on the personal data of individuals. So when you talk about companies and directors,
Okay.
yes, of course, if we have details of, sometimes we get the details of authorized signatories of the company, we get details of directors.
Yeah.
So we are supposed to protect that data in terms of having proper security controls on properly, keeping it secure and not sharing it with, someone who is not authorized, maintaining proper access logs and ensuring the data breach and all. But consent is not required here because this director or maybe, information belongs to that employee of the company. And this act applies to the personal data of individuals. So in that sense, all the CS needs to ensure that apart from consent, the other data protection practices like having proper security controls in place, and that needs to be in place.
Okay, but let's take for example, ABC, a listed entity, has got 50,000 shareholders. Many of them are individuals. Now their data of DMAT and everything, their address, name, father name, nominations that they make is all available with RTA or depository participants and the company by this umbilical cord. In this context, what would be the obligation on them? Whether the consent will apply so far as shareholders are individual?
Yeah. So if you're talking about that company who is taking that data, firstly, we need to segregate who is the data fiduciary and data processor in this case. If that company whose shareholders are giving them the data, company is the data fiduciary in that case. And they need to, follow all the compliances of DPDT. They obviously need to do. So they
Okay.
need to take the consent from the customer, give privacy notices, and all that needs to be done by the company. But if that company is hiring a CS for that purpose, then we become a data processor in that case.
Okay.
So even though consent and all has to be taken from the that company, but we need to maintain the data security of that data.
Okay, thank you so much. It was really wonderful listening to your views, and with the empirical data you spoke about the DPDP Act. It has certainly brought more clarity on even the nuances which were hiding in plain sight. Before concluding today's program, may I ask for your views on what will distinguish DPDP compliant organizations from merely DPDP aware organizations. And with that, you may also give your remarks or takeaways for today's program, uh, which may benefit those who are in audience today.
So I feel an organization who is DPDP, compliant, has all the policies, processes, and technical measures in place to actually, demonstrate their compliance with the DPDP Act. In comparison to a corporate who, just has knowledge about the DPDP but has not enforced it. So if you talk about, finally the why is the DPDP Act so important to be compliant? And what I would say is basically in today's economy, data is more than just an information.
Right.
Data is something which will, help companies with innovation, growth, and having a competitive advantage. So now businesses are collecting huge volumes of personal data. And again, with the huge volume, there comes a lot of risk. So aligning data practices with acts requirement is very crucial. So there needs to be a comprehensive privacy program which integrates governance, risk management, and compliance across all data processing activities. So such initiatives will not only ensure regulatory compliance, but it also positions the organizations as leaders in data protection and privacy, which eventually I think it brings customer trust that my personal data is actually safe with this organization. So I feel organizations or businesses who are working towards implementing and excelling under the under such data privacy laws like DPDP, and those who are actually working on embedding privacy into their DNA and not just their policies, they will go a long way. And this is very important, and which would again help them shift from reactive compliance to a proactive data governance, which is what is required and expected from the organizations to deal with DPDP in the future.
Thank you for summarizing it so precisely. I'm sure people will find it very helpful, and your presentation as well. It was really remarkable. Um, Now, friends, this journey of knowledge sharing will continue, and we will see you next on 9th of January 2026. We are not going to conduct webinars on two successive Fridays, which is 26th of December 2025 on account of Christmas, and 2nd January 2026 on account of New Year's, as there are long holidays. So we would now see you on 9th of January 2026. We eagerly await coming back and sharing our experiences, bringing experts on new topics, and more is to come. The topic of our next webinar is going to be from idea to private equity and venture capital to initial public offering. And we will see you. Thank you so much for joining us today. And thank you so much, Ms. Kothari, for enlightening.